Hello, my name is Faiz Ahmed Khan and I'm a lawyer in Toronto. So before we start, let me give you a disclaimer. This content is for educational purposes only and it does not constitute any legal advice. Every case is unique. You must consult with a licensed lawyer regarding your own specific situation. Today, I'm going to talk about the PRRA loophole no one is talking about, the C-12 ineligibility. Everyone is saying that a C-12 ineligible refugee claim PRRA is bound to fail and the claimant would be deported. Today, we are talking about something that most representatives won't tell you, the difference between a dead PRRA and a live one. If you have been told that a pre-removal risk assessment is a long shot, you're only half right. If you have a C-12 ineligible letter, the math changes completely. Let me prove it to you with the government's own data. So first, let's look at the normal PRRA. This is for someone who lost their case at the Refugee Protection Division, they lost their appeal at the Refugee Appeal Division, and they lost the judicial review application at the federal court. You have been rejected by three separate legal minds even before you get to a PRRA officer. Here is the official data from the last 5 fiscal years which I've got to mention. If your previous claim was referred to the IRB and rejected, your PRRA success rate is only 6%. That means 94% of the time the officer agrees with the judge. This is an uphill battle. You are essentially asking for a second opinion after 3 doctors said you are fine. But wait, there is a second category of PRRA that most lawyers ignore. Now enters the Bill C-12 ineligibility. Here is the scenario. CBSA intercepts someone or a claim is made, but the file is deemed ineligible to be referred to the Refugee Protection Division. Maybe it was a designation issue or safe third country agreement issue or an entry ban, or in this case, a Bill C-12 ineligibility case. The key fact is this: your risk has never been assessed before, not even once. So for the first time, a CBSA officer is applying their minds to your fear of persecution. There is no RPD decision to defer to. There is no ruling of the Refugee Appeal Division. There is no decision of the federal court for judicial review. So this is a blank slate. Now, what is the success rate for those whose previous claim was determined to be ineligible to be referred to the IRB? Their case had never gone to the Refugee Protection Division. The answer is 33%, 1 in 3. That is nearly 6 times higher than the standard 6%. Why? Because the officer isn't checking a judge's homework. They are doing the homework for the first time. If your grounds are strong, the chance of success is exponentially higher than an ordinary PRRA. So, why you need a strategy? Now, don't underestimate me. Don't understand or misunderstand me. 33% is not 100%. But in the world of Canadian immigration litigation, a 33% success rate on a risk assessment is considered a very, very strong bet. So if the officer rejects your C-12 PRRA, you are not out of options. You have two powerful tools still left. Number first, you have a judicial review at the federal court available to you. So if the CBSA officer used improper reasoning or he ignored evidence, we can fight for that decision for you. And number two, humanitarian and compassionate grounds application for permanent residence. Even if the risk assessment fails, you can still apply for permanent residence based on establishment in Canada. But here is the warning: you need to frame your PRRA submission differently. You just cannot argue like you are appealing the RAD because there is no Refugee Protection Division decision. You have to argue facts. You have to argue about the country conditions. And then you have to present your own personalized risk from the very scratch. So what I suggest you is, the actionable advice that I give people is, if you are facing a removal order or if you have a C-12 ineligibility letter, do not accept the 6% fear that applies to other refugees. You are in the 33% category. So you have to do your homework. First, you have to confirm exactly why you were found ineligible under the C-12 category. Number second is you have to gather new evidences of risk that has never been submitted to any Canadian tribunal before. And number third is, do not treat this as a formality. Treat this as your first and the best chance. The data is very clear. A first-time risk assessment wins 33% of the time. That is a statistic worth fighting for. Now, if you want us to review your CBSA ineligibility letter to see if you fall into this 33% window, reach out to my office. Like, share, and subscribe to my channel, and let's win on the data. Thank you.